Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. I will now explain the standards you must apply in determining the amount of compensatory damages to award to Ms. Bovang on each of her claims in the event that you determine that she has proven one or more of her claims. As I explained earlier, in order to recover damages on her defamation claim, Ms. Bovang must prove that she suffered actual harm. Ms. Bovang must prove injury to her reputation or standing in the community, or personal humiliation, mental anguish, and suffering. If you find that Ms. Bovang did suffer actual harm, you may award Ms. Bovang an amount as, in the exercise of your good judgment and common sense, you decide is fair and just compensation for the injury she suffered as a result of a defendant's publication of a defamatory statement. In fixing that amount, you should consider plaintiff's standing in the community, the nature of the statement made about plaintiff, the extent to which the statement was circulated, the tendency of the statement to injure a person such as plaintiff, and all of the other facts and circumstances in the case. Damages of this sort cannot and need not be proven with mathematical accuracy. With respect to Ms. Bovang's remaining claims, that is, her quid pro quo sexual harassment claims under the New York City and state human rights laws, her retaliation claims under the city and state human rights laws, and her assault and battery claims, Ms. Bovang seeks damages for emotional distress. Ms. Bovang is entitled to damages for any emotional distress, pain, or suffering that she has experienced and which she can reasonably be expected to experience in the future as a result of a defendant's unlawful conduct. If you find that any such unlawful conduct occurred, you may not award Ms. Bovang damages for emotional distress, pain, or suffering caused by factors other than the wrongful conduct of a defendant. In order to recover damages for emotional distress, Ms. Bovang must present credible evidence with respect to the nature, character, duration, and severity of the claimed emotional distress. Psychiatric or other medical treatment is not a precondition to recovery. However, nor is Ms. Bovang required to prove her claim through expert medical testimony. You may, however, consider whether psychiatric or medical treatment was sought in determining whether a damage award for emotional distress is appropriate. The purpose of a compensatory damage award is to compensate Ms. Bovang for the actual mental or emotional injuries she suffered and will suffer as a direct result of a defendant's actions. There is no exact standard to be applied. You must award an amount that is fair and just in light of the evidence. The purpose of a compensatory damage award for emotional distress, pain, or suffering is not to punish defendant. Ms. Bovang may only recover damages for harm she suffered. She may not recover damages for any harm suffered by her friends and family. Evidence concerning harm suffered by Ms. Bovang's friends and family is relevant only to the extent that you conclude that Ms. Bovang learned of this alleged harm and that she suffered emotional injury as a result. Ms. Bovang is not seeking damages for economic harm. In other words, she is not claiming that she lost wages or other income as a result of defendant's alleged actions. Thus, even if you find that Ms. Bovang has met her burden of proof on a particular claim, you may not award her any economic damages in connection with that claim. In addition to compensatory damages, Ms. Bovang is seeking an award of punitive damages from Mr. Way, New York Global Group, and FNI Media for the following claims. 1. The New York City Human Rights Law quid pro quo sexual harassment claim. 2. The New York City Human Rights Law retaliation claim. And 3. The defamation claim. Ms. Bovang also seeks an award of punitive damages against Mr. Way on her assault and battery claims. Punitive damages may be awarded for the purpose of punishing a defendant for the defendant's wrongful conduct and to deter others from engaging in similar wrongful conduct. Punitive damages are intended to protect the community and to be an expression of the jury's indignation at a defendant's misconduct. You must determine whether to award punitive damages against each defendant separately. In order to award Ms. Bovang punitive damages, you must first find in her favor against one or more of the defendants on one or more of the claims I just listed. Keep in mind that the fact that I am giving you instructions on punitive damages should not be considered as an indication of any view on my part as to what your verdict should be or on whether punitive damages should be awarded. It is entirely up to you to decide whether or not punitive damages should be awarded in this case. Alright, we will get back to the jury charge, but for now, let's practice some material from this closing argument. Ready? Here we go. Good afternoon. You can make an accident sound pretty complicated if you try really hard, right? I don't really think this is one of those situations. I don't think this is a complicated accident. I don't think that you should think this was a complicated accident. You've heard exactly one version of how this accident happened today. The only person who said anything about how it happened is the plaintiff, Mr. Irvin. Why? Because Ms. Young testified that before this collision between her vehicle and the plaintiff's, she never saw his vehicle and she never saw the truck. And the driver of the only Baltimore Tank Line's vehicle in that area says that he has absolutely no memory at all of what he did that day. Now, he spent some time trying to tell you all what he normally does, and from that they'd like you to decide that on this particular day he did what he ordinarily does, even though he wasn't even able to tell you that himself, okay? There are a lot of things everybody agrees about this accident. Everybody agrees that this is how Mattawoman Beantown Road is laid out. Everybody agrees that it goes from 2 lanes to 4. Okay. Now what you've heard is the court instruction about how we make these kind of decisions, and basically the standard is what's the preponderance of the evidence, what is more likely to have happened than not likely to have happened, okay? And Mr. Irvin has the burden to show that one or more of these defendants was negligent, Baltimore Tank Lines and Ms. Young. Now, what do we know about Baltimore Tank Lines? We know that they admit that Mr. Quaid was their employee at the time this accident happened. They admit that he was acting within the scope of his employment with them on this particular day. And they admit that he was the only driver that they had that was in the vicinity of this intersection and this accident at the time of this accident around 12. And what's Mr. Quaid tell you? That yes, he could have been in this area because he goes through there all the time. He lives right by there. That's how he goes home. He can tell you that he usually comes through this intersection, but he can't tell you if that's what he did on March 13th, 2006. He can't tell you if he went straight on March 13th. He can't tell you if he used a turn signal on March 13th. He can't tell you whether Ted Irvin's car was there on March 13th. He can't tell you if Ms. Young's car was there on March 13th. Mr. Quaid has nothing to say about how this accident happened other than what he normally does, which he can't say happened on this day. And the reason I'm talking about that is you just heard the instructions that the court gave. The judge talked about witness testimony, about how do you evaluate that, and the instructions the court gave don't tell you what to decide, but they give you some guidelines for making those kind of decisions. And what I want you to think is who had an opportunity to observe how the accident happened. Mr. Irvin did. Did Mr. Quaid observe how the accident happened? No. Did Ms. Young observe how it happened? No. She doesn't know anything that happened before there was a car in her lane. Now let me look at my notes, because as much as I'd love to be able to remember all this stuff, I can't quite do it. Now what Mr. Irvin told you he did is that he started out here at some point behind this BTL truck, that as he traveled down the road at a constant speed of about 35 miles an hour, these two through lanes kept going through, and then as you can see on the diagram, the two left turn lanes came into existence. Mr. Irvin said that he started out in this lane, that as soon as he was able to merge over into the turn lane, he did so, and that he was in the outermost of the two turn lanes. Our clunky dialogue for them is the left turn left, left left turn lane, and the right left turn lane. He had to be in the right left turn lane because after he goes through this intersection, he makes this left turn, and then less than a quarter mile he has to make a right turn to get into where he lived. Now next we'll try some literary practice. Excuse me. Let's see what we have here. This is an article that we had been working on. It's called, Do You Know Who Your Car is Talking to? Ready? Here we go. Telematics is part of a much broader trend, however. More and more manufacturers and consumers are viewing cars not just as standalone machines, but also as devices that sync up with smartphones and other personal electronics, or plug into the internet to communicate with cloud-based services. More than 9 in 10 new car owners believe that in the future all autos will connect to the internet, according to a 2013 survey from SGS Advisors, a consulting firm specializing in connected technologies. Before you know it, you'll be able to access a host of internet activities while driving. This prospect does not sit well with traffic safety advocates concerned about the dangers of distracted driving. At your service, automakers and other entities, including the Auto Club, are responding to consumers' desire for increased connectivity by developing systems that connect customers to their cars via their smartphones and computers. Services include sending maintenance reminders and recall notices out to customers, unlocking their vehicles remotely, and finding their cars in parking lots. Examples of systems now available are Ford's Sync, Kia's UVO, Hyundai's BlueLink, Mercedes-Benz Embrace, General Motors OnStar, and Toyota's Intune. No doubt these products and services will help to make driving more enjoyable, more efficient, and maybe even safer for motorists. However, the emerging question is this: who decides how this information is used? As things stand now, vehicle owners are not typically informed about the data their cars collect or transmit, or specifically how the data is used. Let's get back to our opening statements. We're actually almost finished with this one. Ready? Here we go. And so what Mr. Irvin did is, at a constant speed, he immediately merged over into that rightmost left turn lane, and that as he came up, the tractor trailer was next to him at this point, and he was about right here, and it's marked with an H because he was driving a Honda, and he was about midway on this tractor trailer. This is the tanker portion, and this is the trailer portion. And then as he proceeded up, he's gonna tell you that this tractor trailer suddenly came over into his lane, and when he did that, he had to decide what to do. And what he did is, the first thing he did is he moved away from that tractor trailer. Why? He's going to tell you why. Because it's a fuel tanker. He didn't want to get hit by a fuel tanker. Nobody wants to get hit by a tractor trailer, but nobody really wants to get by one carrying fuel because it's a fire hazard. So what he did is he came over into this left lane. He saw nothing in the left lane. When he entered the left lane right afterwards, he was struck from the rear by this Dodge driven by Ms. Young, okay? And what you're gonna be asked to determine today is if anybody was negligent in this accident. And negligence, you hear it a lot, but really what it means is it's just a term for, did somebody act carelessly? Did somebody not use the degree of care that they should have used operating a motor vehicle that day? Now, what our argument's going to be when it's time for you to render a verdict is we're going to ask you to find that the driver of the Baltimore Tank Line's vehicle was negligent by coming over into the lane when the lane wasn't clear and without making sure that the lane was clear. Now, you're also going to have to determine what to do with Ms. Young. Ms. Young's a party in this case because she was involved in the accident, so she's sort of a necessary party. And what you're going to be asked to determine about Ms. Young is whether, she in some way failed to exercise due care whether that would have been by going slower or having a chance to see the accident quicker. But you'll have to determine if she did something negligent that caused her car to hit Mr. Urban's vehicle, and you'll be asked to determine that the driver of the Baltimore Tank Line's vehicle was negligent by failing to make sure that that lane was clear before he got into it. Thanks very much for your attention. Right, and that will actually conclude our literary and jury charge practice for today.